And welcome to the latest in the series of InfoTrack webinars. My thanks to InfoTrack for putting these on. I'm Steve Johnson, Account Manager at CLS Property Insight. And the topic for this course is the thorny issue of the Insurance Distribution Directive. And as you'll no doubt be aware, the IDD came into force on the 1st of October 2018 and requires some adjustment to law firms' procedures in any case where insurance is used as an additional support for risks identified during the legal process. Whether this is defective title or contaminated land insurance and conveyancing, missing beneficiary or early distribution policies in estate administration, all firms needed to be aware of the new requirements. It's modelled broadly on the Insurance Mediation Directive of 2005. There are some tighter controls which we'll highlight as we go through the slides today. So over the course of the next few slides, we'll be covering the statutory background to the Insurance Distribution Directive and of the Insurance Mediation Directive it supersedes. We'll be looking at the modifications to the SRA scope and conduct of business rules and of course the CLC equivalent. We'll look at some of the key requirements associated with being an ancillary insurance distributor, the category that most property law firms fall into. And we'll highlight recommendations relating to activity within the law firm and your dealings with clients to support compliance with the IDD. Now, the IDD arrived on these shores on the 1st of October 2018, and it arrived with a thud. It constitutes about 1,000 pages of legislation, guidance, policy expectation and annexes, covering the entirety of the insurance market through policy providers, intermediaries of various types, and of course service expectations relating to the end clients who ultimately will benefit from the policies which are taken out. It replaces the Insurance Mediation Directive, which had been operating for the 13 years prior. The IMD had provided a revamped approach to the development, recommendation and selling of insurance policies, all insurance being a regulated investment, such as those you and I take out in our personal lives, home and contents, life policies, motor cover. But of course, it also encompassed the provision of legal indemnities of the sort that law firms offer as part of the legal process, encompassing items such as indemnities covering lack of planning, restrictive covenants, chancellor insurance, and the like. All of these policies, of course, form a regular component of the legal process. At a headline level, compliance with the IMD meant that many businesses where insurance was ancillary to the work they carried out could not do anything in relation to insurance policies except provide a leaflet. The pet insurance flyer on the vet's counter springs to mind. However, law firms could, of course, achieve an exemption from this limitation in order to issue policies that met a requirement arising from the common legal process. And that exemption could be achieved by appointing an insurance mediation officer within the firm, registering with the Financial Conduct Authority as an exempt professional firm on their EPF register, and subsequently following the solicitors' financial service rules, conduct of business rules, and the CLC equivalent. The SFS set out that the insurance had to be incidental to the professional service being offered, and the insurance requirement had to arise as a result of that service, i.e. it was subordinate to the legal service. So if the law firm was registered on the FCA EPF, had an IMO in place, then a firm was well on its way to being able to recommend and market insurance contextual to its legal services. Now, of course, the SRA conduct of business rules applied through the course of the Insurance Mediation Directive, and those conduct of business rules govern the how to do it application of the SFS guidance. And this included setting requirements such as, has the firm carried out a market review of the policies and services associated with the insurance requirements of their clients? And this market review is something clients needed to and continue to need to be informed of. It's not just a background activity carried out by the law firm. Are the policies that are passing through the law firm to the end client adequate? Does the firm understand the terms, cover, exclusions, excesses, and ways in which the policy may pay out associated with that policy? And it required the provision of a demands and needs statement to the client, setting out the key policy terms and enabling the communication of the policy in a clear and intelligible way. So what then were the overarching principles that the Insurance Distribution Directive brought in when it replaced the IMD in 2018. Well, the UK was in a strong position to implement the requirements of IDD, the IDD being a European-wide requirement. We already had, in the form of the IMD, a stronger regulatory requirement for insurances than many territories. And in fact, there was much in the IDD that is a reflection of the position that's already held by the IMD. However, there are some areas relevant to law firms where the IDD has introduced a greater level of clarity on what is expected of law firms in relation to insurance services. It remains the case that all insurance is a regulated activity, and that any dealing with insurance requires authorization or exemption. And that exemption is only available if insurance is ancillary to services, and obviously in our case, legal services. Now, amongst the principles of the IDD are that distributors, of which an exempt law firm is such, must always act honestly, fairly, and professionally in accordance with the best interest of the customer. Nothing controversial there, of course. The IDD also provides a stricter approach to demands and need identification and matching insurance products to those needs for the client, and continues to say that the firm must offer products suitable for customers' demands and needs. And the IDD also states as a core principle that distributors, and this applies all the way through the chain of provision through companies such as ours, yours, and on to the end client, must also be of good character and good repute. Now, in addition, the IDD brought in requirements that many of us in the insurance industry now undertake, namely that those involved in insurance distribution maintain 15 hours of CPD per year. And it's interesting, this has come in just as the SRA has moved away from that specific need for 15 hours to a general requirement to carry out and document suitable levels of continuing professional development. However, from a law firm's perspective, please note that though in practice this applies to two of the three statuses of intermediary named in the IDD describes two intermediary statuses, namely insurance intermediary and reinsurance intermediary, both of which are required to do those 15 hours of CPD by their staff. But the third category of ancillary insurance intermediary need not maintain those 15 hours of CPD, and it's into this category that most law firms fall. Please note, though, that this exclusion does not remove the need to maintain knowledge of the insurance market and the policy being issued by to clients. So you may still want to build insurance policy and market knowledge development into your annual training programs. And if that is the case, then that's certainly something we can help with, and I'll describe those a little bit later. Now, the status of ancillary insurance intermediary is one achieved where a company provides insurance as a result of a phase in a primary service. And it's of course into this category that the recommendation or provision of legal indemnities in the context of a property purchase falls. The IDD also brought in 2018 a requirement for a comprehensive complaints policy applicable to clients, but also to non-clients who may have had an interest relating to the insurance services law firms provided to a client. So that complaints policy has to encompass clients and non-clients, as I say, who may be indirectly affected by a decision the law firm has made relating to insurance. From a policy document perspective, IDD brought in the principle of a policy having an IPID, Insurance Product Information Document, to provide extra clarity on the nature and conditions of a policy for those who may take them out or indeed distribute them. And if you're not familiar with where the IPID is in the policy drafts from your chosen supplier, it's certainly worth familiarising yourself with them, as it will help with your communication of the policy and adherence to the clear communication obligations contained within the Insurance Distribution Directive. So what then are the forms of activity that a law firm or indeed an individual would need to carry out to adhere to the requirements of the IDD? Well, registration on the FCA Exempt Professional Firm Register continues to be a must should you provide any insurance services, and of course many firms are already registered. At CLS, we always check the EPF status of any firm that is applying for policies that we provide. And we still periodically receive policy requests from firms who turn out not to have been registered. They, of course, have to complete that registration before we can progress the policy. Through the oversight provided by the firm's insurance distribution officer, the firm should ensure its staff are competent to deal with insurance offerings and proactively up to date with any policy or service development. Training and knowledge maintenance is one area where the law firm's general training program and the IDO implementation of IDD requirements coincide. This theme of training and knowledge maintenance is one of the pieces that the IDD has really brought in for anyone acting as an insurance distributor, and that, of course, includes law firms. You'll notice that I use the term Insurance Distribution Officer, and this is down to the fact that the IDD requires what was previously the Insurance Mediation Officer to be rebadged as an Insurance Distribution Officer. And this officer continues to be the one responsible for insurance distribution activities. They must be within the management of the law firm and will be responsible for the insurance distribution activities, associate policies, commercial decisions on which supplier best fits client needs. So if the music has stopped playing, make sure you sit down, because that could end up being one of the roles you have to take on. In addition, there are other requirements, such as ensure the firm acts honestly, reasonably, fairly and professionally and in the client's interest. The firm should make appropriate pre-contractual disclosures about the nature of its relationship with the insurer. So, for example, if the law firm or any individual has some level of ownership in the law firm that has a 10% or greater stake in the insurer, that should be disclosed. Likewise, if there is any remuneration that the law firm is receiving for the sale of insurance policies, that should be disclosed to the client prior to them making the decision to buy a policy. And as we've already mentioned, there is an enhanced requirement to understand the client's demands and needs by asking appropriate questions and matching the products and assisting the client in making appropriate choices. Also, of course, there's the understanding of the actual policy. What are the conditions? When would claims be paid and when not? In addition, providing information in a meaningful and durable way continues to be key, as was the requirement under the IMD. Now, regarding InfoTrack and CLS and these knowledge requirements, you can take advantage of a range of training courses, and also, should you wish, what would have been potentially a face-to-face visit, but in current times an online visit from one of our underwriters, and particularly at the moment with people having perhaps slightly less work to do, maybe not the case across the board, but we've seen a significant uptake in our online training courses and, as I say, online meetings with underwriters. So for those of you that maybe are the IDO in your firms, if you wish to have your firms briefed and able to ask those difficult questions about the nature of legal indemnities and policy conditions and what's covered and what isn't, and would like to book a meeting with an underwriter, please do contact myself or InfoTrack, and we'd be only happy to arrange a Zoom or GoToMeeting or whatever's appropriate for yourselves in order to maintain your understanding of insurance services. Now, in response to the SRA, and in response to the IDD, the SRA and the CLC have both updated their rules to support adherence to the IDD. Often the changes are amendments to or extra clarity provided on rules that were in place under the previous Insurance Mediation Directive, but there are some points where the emphasis is far greater. Firstly, across all of your client-facing and policy documentation, the previous phrase, insurance mediation, should be replaced with insurance distribution. That applies to the job title for the IDO, of course, and also applies without exception to your client care letters and your terms and conditions and so on. Also, you should change the wording in your client care letters to read words to the effect of, we are not authorised by the Financial Conduct Authority. However, we are an insurance distributor and are included on the insurance distribution activity, which is broadly advising on and selling and administration of insurance contracts. In addition, information provided to your clients on policies should be clear, and those of you that are InfoTrack CLS clients, please note that suggested communication text for each and every one of our legal indemnities can be downloaded from our order platform. Information should be provided to clients in good time before the inception of a policy. Good time isn't a clearly defined term, but this is so that the client can have sufficient time to consider in full the suitability of the policy. Of course, different clients will take different time to review insurance documents. I'm sure I'm not the only one that is left renewing my car insurance to the very last minute. You should also make clear if you are making a recommendation relating to a policy, and if so, why. And it's perhaps the final section on screen, which is the area that the IDD has most enforced compared to the IMD, namely the extent to which the law firm must take account of and understand really the specific insurance requirements of the client and match those to a suitable policy. Requirements such as adapting the complexity of the insurance contract to the client's needs and giving a personalized explanation as to the suitability of the policy or the client's needs now apply. And that is tied in with the continued supply to the client of a demands and needs statement. And once again, I draw your attention towards the IPID and the value that potentially has in helping with your communication to client. Now, in addition, there are some additional requirements the IDD has brought in. One should only use registered insurance intermediaries. You should ensure prompt and fair treatment of complaints in line with the insurance complaints policy that the IDO is responsible for commissioning. And as I mentioned, that treatment of complaints extends to non-clients as well as clients of the firm. There is a condition that there should be no remuneration that would conflict with the best interests of the client in relation to insurance policies issued, nor should there be incentives or sales targets to sell insurance that would motivate insurance to be sold in cases where it was not the best route for the client. There are numerous examples of the value a client can gain from legal indemnities where a policy is called upon, whether it's in terms of financial cover delivered by a policy or in terms of access to legal advice and expertise that would otherwise have to be paid for. But equally, there may be cases where investigation of a risk may be a suitable course of action instead. Ultimately, it's for the client to decide the pros and cons of each course of action. And if there are remuneration agreements, they should be notified clearly to each client who may take out a policy you recommend. Likewise, if the client has to pay a fee for insurance, explain how the fee is calculated. And if insurance is offered as part of a package, the client must be able to buy those insurance products separately if they wish, or not at all, of course. So we are now coming to the end of the webinar. I certainly hope you found this helpful. If you have any questions regarding the content of the webinar or wish to take up any of those online underwriter Q&A sessions, please do get in touch. My contact details are on screen, as are those of InfoTrack. And my thanks again to them for arranging this webinar. You'll receive a copy of the slides shortly, and I would like to take this opportunity to say on behalf of everyone at InfoTrack and CLS Property Insight, please stay safe, stay well, and stay in touch.